Good morning, good evening, good afternoon, wherever you may be. My name is Chris Simmons, attorney at law, and today we're going to go over a case that was just handed down from the Supreme Court today, Jennings versus Rodriguez. Now, what this case does is it essentially says that if you're an immigrant, no matter whether you're legal, illegal, you're a lawful permanent resident, you came here on a visa, you came here crossing the border illegally, you were brought here as a human trafficking victim, no matter what. If you are in deportation proceedings, according to the majority in this particular case, you don't have a right to bail. You also can be detained indefinitely as long as your hearing is ongoing. Personally, I disagree with this opinion wholeheartedly. I think that they skipped a lot of things that they shouldn't have, that the dissent brings up. I think they skip over context, historical context, some of the actual words in the statute. I think they skip over some things. And here's the thing. I think this, as it stands right now with the majority opinion, what's going to end up happening is that it's going to be challenged yet again, and we're going to be in a place where, because of this ruling, these sections may be ruled unconstitutional because they violate due process, the Fifth Amendment due process, that everyone, whether you're a citizen or a non-citizen in the United States, is guaranteed. You're guaranteed due process in the United States, no matter who you are. So that's the nutshell version of this. The way we're going to do this is I've put my notes over here on the right side of the screen. I have a full case on the left side of the screen. If you'll notice, I have page numbers for some of these things. I don't for other things. I have a summary of pretty much all the arguments. This is pretty much what I'm going to be going off of. But I'm going to show where it is in the document. I'm going to link the actual document below. You can follow along if you'd like. Please, by all means, read the full opinion if you can. It is fascinating. I will not be going over jurisdictional arguments, which also means I'm going to be skipping the concurring opinion from Justices Thomas and not Ginsburg, Gorsuch. My mistake. So I will only be dealing with the majority opinion written by Justice Alito and the dissenting opinion written by Justice Breyer. So first of all, let's figure out what we're talking about. So let's talk about the facts. So Rodriguez was a Mexican citizen, but since 1987 he was a lawful permanent resident. April 2004, he was convicted of a drug offense and theft of a vehicle, and he was placed in removal proceedings. Both an immigration judge and the BOA, the Board of Immigration Appeals, found that he was to be deported. He appealed to the Ninth Circuit, and 3 years later, he files a habeas petition. Now, what is a habeas petition? Well, a habeas petition is a petition to be brought before a court to challenge your detainment, your imprisonment. It can either be that your detainment is unlawful, the conditions are unlawful. There's a number of things that a habeas petition can allow you to do. Understand that this is a right that you have as an American citizen no matter where you are. In fact, if you're in the United States, you have this right. It cannot be taken away from you except through an act of Congress, and only temporarily, and only in the most dire of circumstances. So that's what a habeas petition is. So he's alleging that he's entitled to bail. I'm pretty sure I should have written bail here, not bond. I do that a lot during this. So if you see bond in my notes, I'm talking about bail. So it's also a class action. This was consolidated into a rule of Civil Procedure 23B2 class action. What this means is that everyone in this class has a common question of law and a common question of fact, and that everyone here is being denied some type of injunctive relief. Not monetary damages, but there is a refusal to do something. So the class is all non-citizens within the Central District of California who are or were detained for longer than 6 months pursuant to one of the general immigration detention statuses pending completion of removal proceedings, including judicial review, are not and have not been detained pursuant to a national security detention statute, and have not been afforded a hearing to determine whether their detention is justified. So that's where we are. That's the facts of this. So what's the argument that the respondent, Rodriguez, is putting forth? This, if you want to think of this as a law school brief, this would be your issue. The issue is, does sections, and that's what these little symbols here, if you aren't aware, this symbol here is a section symbol. Sections 1225B, 1226A, 1226C do not authorize prolonged detention in the absence of an individualized bond hearing at which the government proves by clear and convincing evidence that the class member's detention remains justified. And this is on page 11. And so let's skip there so we can look exactly where it's at. So this is exactly where I summarize this. Okay, you can see it right here. So we're skipping jurisdictional arguments. We're going to go straight into the majority opinion. So what we're going to need to do is skip around a little bit to get to the meat of the argument. I'm going to read off of my notes for a little bit. Just because I don't want to skip around, because this video is already going to be long and I don't want to spend time running through. So, relying on constitutional avoidance canon, appellate court construed that sections 1225B and 1226A and C to limit permissible length of an alien's detention without bond hearing. Without such construction, prolonged detention without adequate procedural protections authorized by the provisions would raise serious constitutional concerns. This is what the appellate court was saying. Now, what does this mean? Well, this means that the appellate court, in order to maintain the constitutionality of the act, of these statutes, determined that they had to use a canon called constitutional avoidance in order to find an interpretation that would keep these statutes constitutional. You'll see this argument in the dissent in a little while. SCOTUS says interpretation is impossible. I'm pretty sure everyone knows this, but anytime you see SCOTUS in my notes, that is Supreme Court. Just so you're aware. So, Supreme Court makes two categories. Okay? Asylees and 1225B2. 1225B2 are just other removable aliens. Okay? Both, so what I mean by both is that this argument is for asylees, this argument is for 1225B, shall be detained for further consideration of the application for asylum, and 1225B2 shall be detained for removal proceedings. Those are the people who we're talking about. So anyone who fits within one of those two categories. That's why this is far-reaching, by the way, because this will cover anyone who is an immigrant who is in removal proceedings, including LPRs. lawful permanent residence. So the majority says, read most naturally, sections maintain, these sections maintain that detention of applicants for admission until certain proceedings have concluded. What this means is that, read most naturally, these sections actually say that detentions have to be detained until these are concluded. It doesn't give a limit, or it does give a limit, I'm sorry. It does give a limit. It's not indefinite, it's just until they're detained. So, the reason that SCOTUS said it was implausible, well, the 6-month limit is the normal, but respondent Rodriguez contends that after 6 months, you must be detained under Section 1226A. The majority says there's no hints to this within the statute, and the respondent apparently doesn't even attempt to defend a 6-month reading. This is page 18, so let's skip there. I'm going to do this whenever I see a thing, so you can read it right here. Actually, this on the left. This is pretty much what is in my notes. Okay, so you can fact check me right here if you'd like. Respondent relied on, and I am bad at pronouncing this, Zadvidez, I believe, versus Davis. I'm just going to call it Zadvidez from now on. SCOTUS says 90 days only applies to final orders of removal, not while pending. Now, what that means is that they're distinguishing this case from Zadvidez. In Zadvidez, the court said that the 90 days, if you were detained more than 90 days after you have been ordered removed, but you haven't actually been removed, you may get bail. They're distinguishing this. So they're saying that if you are ordered removed, you can get bail. But if you haven't been ordered removed and you're just in the proceedings, you can't get bail. I know it doesn't make a lot of sense, but they have actual reasons, and it comes down to statutory interpretation. Okay. So they say there's a material difference between 1231A6, which is Zadvidez, and 1225B1 and B2, which are the categories that we are talking about. 1225 has a specified period of time, whereas 1231 does not. And additionally, 1231 uses the word may, whereas 1225 does not. So may is some ambiguity, and the majority is arguing that because there's no word may, there's no ambiguity here. So, second argument for the majority. For means until the start of the applicable proceeding, there's a big difference between for and pending. I should put quotations marks around this to make it more clear. What they are saying, what they're arguing, is over the meaning of for, F-O-R. And this is how nitpicky that these Supreme Court cases on interpretation can really get. You will argue over the meaning of words like for, pending, during, detention, stuff like this. So anytime you see for, we might as well just put quotation marks around it to make sure. So the Supreme Court says for can mean during or throughout, or it can mean in preparation for or anticipation of. For respondent's interpretation, government could detain. Okay, so here's what's happening. If we follow the respondent's interpretation, this is what the majority is saying could happen. The government could detain without a warrant at the border, but once removal proceedings began, the Attorney General would have to issue an arrest warrant in order to continue to detain the alien. Basically, what they're saying is, they catch you at the border, well, they can detain you. But the moment that they start some type of removal proceedings, well, now they have to have a warrant. That's how the majority is interpreting. So, the interpretation, according to them, doesn't mesh with how Congress has historically used the word for and pending. I find this interesting that they use this because they don't go into a lot of the other historical precedents and historical context around some of the other arguments. Instead, and you'll see it right down here, if we were to go to where they attack the dissent, which is page 25, and we'll go ahead and go there. We'll come back to this a little bit, but when we get to that point, they clearly state that oh wait, no, that's might have, oh, I put it in the wrong thing. Here we go. Page 25 of the actual thing. Sorry, my mistake. Anyways, what they do is they say that the dissent has this 19-page intro before they actually get to what we're talking about. And they basically, at least to my reading, they hand-wave 19 pages of the dissent, and they just ignore all the historical context that they bring up. So I find this very interesting. So let's continue. 1226 applies to aliens already present in the U.S. Doesn't have an explicit time limit. Reinforces only be released. I'm not sure what I wrote there. I'm sorry. So what they're saying is 1226. What the respondents are arguing that the bail should be under. It only applies to people already present in the U.S. and because it doesn't have an explicit time limit, therefore bail. It mandates detention pending a decision on whether the alien is to be removed from the United States, 1226A, and it expressly prohibits release from detention except for narrow witness protection purposes. So what they're saying is that there's a section in this that is over witness protection programs. The dissent brings this up, but they're saying that that's the exception to the rule, as opposed to that section only applies to that section and has no bearing on the other parts. So that's a difference in interpretation between the majority and the dissent. Let's see. Interpretation doesn't, we've already been over that. 1226C has a definite endpoint, conclusion of removal proceedings. Patriot Act and 1226C apply to different classes. So the dissent decided that they were arguing that interpreting 1226C to have no definite endpoint would actually be a violation of the Patriot Act. It wouldn't mesh with the Patriot Act. The majority is saying that the Patriot Act applies to a different class of aliens than 1226C does. And finally, the majority states thus, 1226A does not contain text that even remotely supports the imposition of a 6-month periodic bond hearing in which the Attorney General must prove by clear and convincing evidence that the alien's continued detention is necessary. That's what they're ruling. And when we get to the dissent, we will see why that may not be so. This was a 5-3 decision. Justice Kagan was absent. She recused herself. I apologize for noise in the background. My pet is in his cage drinking, and I'm not going to stop the recording to stop him. So that's what it is. They attack the dissent. They go on to say detain means the absence of unrestricted freedom. It's their attack is very, I don't know how to describe it particularly. So we're going to move on to the dissent now. Again, we're skipping the concurrence because it's basically that the Supreme Court has no jurisdiction. Okay. So let's go to the dissent. This starts on page 49. So page 49. This is Breyer joined with Ginsburg and Sotomayor. You'll have to forgive me, my notes are less clear sometimes on this. So, the dissent basically restates some facts and explains some things that the majority didn't either didn't address or that they think that they didn't address in the correct way. So, some simple facts that are left out of the majority opinion. The government holds people for months or years, despite the fact that many of them ultimately win their claims. In fact, if we look down here, right here, detention is often lengthy. This class, meaning the class that they've defined, are those detained for at least 6 months and on average 1 year. Some were detained for up to 2.5 years before they won their asylum case. Some were detained, or they detained at least one person for 4 years after a criminal conviction was finished, and they still won their claim. This is page 51. I'm going to point this out because it gives you numbers. You can read the numbers right here and what I was talking about. They redefine the classes. They tell us exactly who we're talking about. These should be together, but I'm going to just take it from here. Asylum applicants, not asylees, because asylee is someone who has already been granted asylum. So asylum applicants have been found to have a credible fear of persecution. All those committed a crime have already served their sentence, and those seeking entry have a strong claim for admittance. These are the types of people we're talking about with this. So it's not like they have no claim. They have a strong case to make. They just don't have a perfect case. And again, ultimately, a lot of these people end up here. They end up winning their case. Additionally, the dissent accuses the majority of ignoring the fact that the asylum seekers would receive bail hearings if they were already in the United States. So you're treating asylum seekers as two separate classes. All of them are held within facilities in the U.S., although there is a legal fiction that perhaps these people, even though they're held in facilities within the U.S., are not actually in the U.S. That is a legal argument, as a legal fiction, and they address that right down here. And finally, detention is similar to those in many prisons and jails. So, here's the crux of their argument. The majority interpretation would raise grave doubts about the statute's constitutionality, specifically about Fifth Amendment due process, which, and I'm going to highlight this, page 55, we're going to highlight it right in the text. It is clear that the Fifth Amendment's protection extend to all persons within the territory of the United States. That is citizens, that is non-citizens. If you're in the United States, you get Fifth Amendment protections, you get due process. In fact, the Eighth Amendment reinforces the Fifth Amendment by saying that excessive bail cannot be set to prevent someone from getting out of jail on bail. So bail is a fundamental part of due process. Now, to go back to the legal fiction that all are held in facilities within the U.S., we're going to quote this right here. But once we admit, you'll see right up here, this is the legal fiction. This is the answer. The legal answer to this question is clear. We cannot here engage in this legal fiction. No one can claim, nor since the time of slavery has anyone, to my knowledge, successfully claimed that persons held within the United States are totally without constitutional protection. Whatever the fiction, would the Constitution leave the government free to starve, beat, or lash those held within our boundaries? If not, then, whatever the fiction, how can the Constitution authorize the government to imprison arbitrarily those who, whatever we might pretend, are in reality here in the United States? The answer is that the Constitution does not authorize arbitrary detention, and the reason that is so is simple. Freedom from arbitrary detention is as ancient and important a right as any found within the Constitution's boundaries. See Zedvides. And that was it from a dissenting opinion, for the record. They go throughout this. They go over the reason for bail historically. It's you generally do it to avoid a flight risk and to allow non-dangerous people out while trial is pending. Even a convicted person could appeal and be let out on bond as long as their appeal wasn't frivolous and as long as the court had reason to believe that no one or more conditions of release will reasonably assure that the person will not flee or pose a danger. Same reason for bond everywhere. The problem here is that this case is civil, not criminal. If this was criminal, it'd be open and shut, but unfortunately, this is a civil case because immigration and deportation is civil, not criminal, and that is a huge difference. But the dissent has an answer for this. So there's not many cases of civil detainment, but mental health has similar process with a yearly review. Bail would be pointless in those, as those that are kept in those under that type of detainment are normally violent and wouldn't be eligible for bail anyways, but they still get a yearly review. And even during extradition hearings, these are where we're going to extradite someone to a foreign country. Those people are still get a bail hearing. So the idea is to treat like. Civil detainment is like a pretrial detainment where bail is available. Criminal defendants get bail. They often lose their case. Non-citizens in deportation proceedings, they don't get bail, but they often win their cases. There's no more risk of flight, no more risk of danger from a non-citizen than a criminal defendant, but there is a difference between the bond hearings. So, finally we get down to, we're going to skip down to page 67. So, basically what we're here is what the appellate court argued. We have two possible interpretations of the statute. The Supreme Court can either interpret it in a way that would make the statute unconstitutional, or one that would save the act. The dissent is saying that it is their plain duty to adopt the one that would save the act. And that one would be to allow bail on a 6-month period, as is kind of tradition at this point, as it's been used elsewhere. I'm going to read this, 71. We're going to go down to page 71 so we can find where this is. Congress does not. Here it is. Congress does not unambiguously authorize long-term detention without bail by failing to say that when detention must end. As we recognized in Zadvides, Congress anticipated long-term detention elsewhere in the Act, providing for review every 6 months for terrorist aliens detained under 8 U.S.C. 1537 B2C, but it did not do so here. So basically, they're saying, look, Congress specifically addressed long-term detention. They specifically gave them review every 6 months. What you're saying is that because they didn't say that explicitly in this one section, doesn't mean that they didn't intend for it. And actually, that's borne out by the rest of the Act. And this is what I'm astonished that the majority did not address. In the Act, in the very same Act, an asylum applicant, Congress clearly states that proceedings need to finish within 180 days, because if a proceeding lasts for more than 180 days, they allow work authorization. The idea when the Act was enacted was that these proceedings are not going to be backlogged for 18, 24 months at a time. The proceeding is that, or the Congress anticipated that this would not take longer than 6 months, so this wasn't something that was on their mind. In fact, when it was specifically on their mind, they gave review. That's what the dissent is saying. The only if section in 3521, that's the witness protection program that was referenced in the majority. They're saying that the dissent says that that only has to do with that special program. Doesn't have to do with everything else. So basically, if I can summarize this, the dissent is kind of saying that the majority is picking and choosing their interpretation. So finally, we end with this. It would be anomalous. Those who are in proceedings could be indefinitely detained. Those who have final order of removals but haven't been removed could get bail after 6 months. That's a weird thing. Like, you can be held for 4 years without bail, but if they fail to remove you after you've been ordered removed 6 months later, you get bail. It's really weird. Finally, I want to point out the very end. This is on page 80, so we'll skip right over there. I'm not going to read this particularly, but it's right here. This is how the dissent finishes, with an appeal to the very words of the Declaration of Independence. So that was a quick, dirty overview of the entire case. There's some stuff I left out. Please go read it. I can't go line by line, otherwise we would be here all day. So I'm going to give you some final thoughts. I alluded to all this at the very beginning. I'm going to give you my interpretation, what could happen, and just general ideas. So first of all, the majority interpretation potentially causes the statute to be unconstitutional, a violation of due process, Fifth Amendment due process. It ignores a lot of historical context. it ignores a lot of other pieces of interpretation within the actual act. I don't know whether it is the fault of the respondent for not sufficiently arguing it, or if the majority is just picking and choosing. I haven't looked at the briefs, I haven't heard the oral arguments, I can't make that determination for myself. Only speculation, and speculation is not particularly useful when it comes to why a justice ruled a certain way. Excuse me. What I can tell you is some of the long-term effects and what needs to be done. So what I predict is that this is going to be kicked back down to the appellate court. The appellate court is going to rule that indefinite detention is a violation of due process. It's going to be kicked back to the Supreme Court, and instead of addressing it now, like the dissent suggests within this opinion, which they already had the briefs to do apparently, they're going to have to rule on it based on the interpretation that the majority has already done. And they're going to have to either say that indefinite detention is not a violation of due process, which is wholly against every other form of detention we've ever had. Like, that's ridiculous and would go against so many precedents. Or they're going to rule that these acts are unconstitutional, and then they're going to have to rewrite them in a way that makes them constitutional, which probably means that either they have to insert the bail portion in there to read it into that, which the dissent is doing, or we don't know what's going to happen. The better solution to all this would be call Congress, call your Congress people, have them rewrite these sections to include a mandatory bail hearing after 6 months. Right now, as this is, Congress is the only one that can fix this. I am going to compare this to something that may be controversial, and a lot of people may disagree with me, but I see this as an opinion along the lines of a similar opinion called Korematsu. And Korematsu was the Japanese internment camp opinion that said that Japanese internment camps are lawful. Because that's basically what it's saying. It's saying that people within this, who are in these proceedings, can be detained indefinitely. So a couple of other problems with this. Human rights violations predominantly are completely possible. But immigrants aren't criminals. They are detained under civil detention. It's not criminal. They don't get the same criminal protections as a criminal defendant. They don't get access to a lawyer. They don't, well, not automatic. They don't get a lawyer assigned to them. Oftentimes they are held with the actual prison population, which a pretrial detainee should not be. And in fact, these people should be considered pretrial detainees if we're going to consider them anything. They now don't have access to bail. They can be detained for however long the proceeding lasts. And in fact, if you are a less aggressive, less violent, and pose less of a risk, you're going to be detained for longer, because those people who are violent, who are a risk, they get prioritized for deportation. And that means that they don't have to be detained as long, while those that aren't as violent, aren't at risk, well, they're going to have to be detained for longer because they aren't prioritized. the entire idea is ridiculous. This could potentially end in what I call lifers. And basically what that means is it's for asylum applicants for the most part. So what happens is that an asylum applicant proves they have a well-founded fear of persecution, but for some reason they fail the actual application. It could be for technical reasons, it could be for credibility reasons, it could be for any number of things. But they fail their application, they are put in removal proceedings. Well, they've already proven that they can't go back to their home country. Normally, they would get out after 6 months, but because we can't remove them, the proceedings may never end because we just don't know. We may not be able to determine if we can actually remove them or not. So what can happen is that we either have to put a final order of removal, and then 6 months later they get bail because we can't remove them, or they prolong it and they stay detained for as long as the government holds out on that. So it's a very precarious situation. Generally, I am all against indefinite detention. I'm all for human rights. I'm all for due process rights. This ruling spits in the face of all of that. So I don't agree with it. It's part of the law now, though, so we're going to have to work around it. The best option, like I said, call your congressman. Get this fixed through Congress. I know it's not likely to happen with the current Congress, but this does need to be fixed. Otherwise, we're going to have a ton of legal challenges to this. But as of right now, this is the Supreme Court, basically saying we can indefinitely detain immigrants. And that is something that's something that's going to be extremely problematic going forward. So next video, I will continue my free speech series. We'll start with commercial speech. That was put on hiatus for a while due to other reasons. I will not be. I'll go into at a later date when it's finished completely. So expect that. But I can't believe we're at the point where we have such a bad ruling. I thought maybe we'd learned something, but I guess not. So that's the ruling. I'll see you in the next video.